Morning, everyone. I want to welcome you. I'm Bill Silva. I'm the Associate Executive Director at the Connecticut Association of Schools. And I want to thank all of you for taking the time out of your morning to join us for today's webinar, our eagerly anticipated webinar from two wonderful guests that we've frequently had here at CAS, and I know you'll enjoy them again this morning. Webinars today, What's New in 21-22, a legal update, presented by our distinguished guests, attorneys Tom Mooney and Natalia Sieira Millan from the law firm of Shipman and Goodwin. Before I introduce Tom and Natalia, I want to thank our corporate partners at CAS, the College Funding Coach, Horace Mann, and MCM Fundraising for their ongoing support of CAS's high-quality professional development for school leaders in Connecticut. I also want to go over how we will proceed with the webinar. During the presentation, you in the audience are muted, but you may share any questions you have using the Q&A feature, and our presenters will try to answer as many questions as they can during the hour and a half we have this morning. We are also recording the webinar, and we will make that recording available to you in the next few days. Now let me introduce our presenters. First, attorney Natalia Sieira Millan is an associate at Shipman and Goodwin and a member of the firm's school law practice group. A graduate of Boston University and the Quinnipiac School of Law, Natalia was the assistant agency legal director with the Connecticut Department of Children and Families and a Connecticut State Superior Court law clerk prior to joining Shipman and Goodwin. Natalia teaches school law courses at the University of Connecticut NEAG School of Education and at the School of Education at Quinnipiac University. Attorney Tom Mooney, well known to most of you, I'm sure, as a partner at Shipman and Goodwin and the author of A Practical Guide to Connecticut School Law, now in its 9th edition. In addition to his extensive practice in all areas of school law, Tom teaches at the University of Connecticut School of Law, serves as professor in residence at the NEAG School of Education at the University of Connecticut, and is adjunct professor in both the School of Law and the School of Education at Quinnipiac University. A graduate of Yale College and Harvard Law School, Tom has been widely recognized for his many notable contributions to the law and to education in Connecticut. Both Tom and Natalia are good friends to CAS, and we are so happy to have them here to provide their insights and guidance on the legal landscape facing school leaders this school year. So welcome, Tom and Natalia. Thank you so much for being here. And I turn the presentation over to you.
Great. Well, thank you, Bill. And thank you, Karen, for running the PowerPoint as we go through this. It's good to talk with everyone. I almost said see everyone, but I can't. But I see that we have a number of people here, and we're delighted that you took time from your busy schedules to listen to us talk about some of the more interesting new legal developments that school officials confront. Our plan is to answer 10 questions that you didn't know you had about school law and what's new in 21-22. Natalia and I will alternate asking and answering those questions. And as Bill indicated, we hope to have time not only at the end of the presentation, but during the presentation. We've scheduled this for an hour and a half, and we have 10 questions. So our plan is to spend about 10 minutes per question, and then offer you an opportunity for free legal advice at the end of the presentation. So I'll just start. And, well, one other thing, sorry. The legal developments specifically related to statutes are many. Excuse me. The General Assembly was inhibited last year through the COVID crisis, so they more than made up for it this year. And there's a whole load of new statutes to worry about. At the end of the presentation, we'll be providing, or CAS will be publishing detailed materials about the questions and answers we've discussed today, totaling around 17 pages worth for your reading pleasure. In those materials, we have a link to our legislative update for this year. It's quite extensive, And it should serve as a good resource for you if you want to know more about the issues that we discuss, and also about the many statutes that we didn't have time to cover today. So that resource is coming, but we thought it would be most effective to talk with you and not have you reading while we're talking. So we're going to talk, and then at the end of the presentation, our materials will be available. So with that introduction, let me ask Karen to pose the first question. And I'm sure this is on the minds of many, and that is, I've heard about these mental health days. Where can I get some? And the answer is you can't, but there is a new statute about mental health days. And specifically in Public Act 2146, and let me just take a step back. With the pandemic, the General Assembly was legitimately concerned about the mental well-being of students and concerned about equity. So there are many statutory enactments this year that deal with the social emotional well-being of students. One of those statutes deals with mental health days. So what we have in Public Act 2146 is a new concept, and that is that the General Assembly has established something called a Mental Health Wellness Day, and that is defined as a school day during which a student, not a school administrator, but a student, attends to such students' emotional and psychological well-being. And for the school year commencing July 1 of this year, so we're in the middle of this already, and if we were in person, I'd ask for a show of hands, how many of you have received your first request by a student, not request, notification from a student that he or she has taken the day off to, quote, attend to his or her emotional and psychological well-being. The statute says that these days are available this year. And interestingly, they can't be taken on consecutive days. So they have to be spaced out, apparently. But what this presents to us is a challenge of interpretation. And that challenge relates to the question of how this fits in to the excused and unexcused absence structure that the State Department of Education established some years ago at the directive of the General Assembly. And as many of you know, the State Department of Education has said that parents have the unilateral right to excuse up to 9 days in a school year without further documentation. And after those 9 days, there are certain specified excused absence days, and otherwise, the question is, shall these days be excused? And the State Department of Education has laid out expectations in terms of documentations. For example, if a student has burned through all 9 excused days and gets sick, then some medical documentation is required. Well, now we have this new concept of mental health days. And the question is, how do they fit in? This is as I mentioned, this is a notification. It's not a request. It's not an application. So a student wants to take a mental health day and they say so. Well, what if that's within the first 9? There haven't been 9 excused days. Does that count against the 9? Or what if the day comes after the 9 excused days have been taken? Now, what kind of documentation is required? Well, that's not clear from the statute, but we have to figure it out as best we can until someone tells us differently. And the way we figure it out is that students have the right to take a mental health wellness day. If it's before 9 have been excused, then it's one of the 9, because it's a day that is excused by right and parents can do it. But if the student has taken the 9 excused days, and now we're into the documentation, We think that given the statutory unconditional right they've given to students to take mental health wellness days, that they would automatically be excused. So that's where we land. And there's an interesting related point, and that is a couple years after this excused, unexcused absence construct was established by the State Department of Education, the General Assembly added a different excusal process, and that is that if a student's parent is on leave or has immediately returned from deployment to a combat zone, then they automatically get 10 excused absence days if they want them. That is a separate statutory provision. And again, there's no particular guidance on it. We don't have, happily, any court cases on it. But we would look at that as a completely separate issue. And it's one we would expect to occur rarely, but we would interpret that to be separate, and they would simply make application explaining the situation, and those up to 10 days would be excused outside of the construct of the 9 excused days unilaterally and additional excused days with documentation. I do want to tell you that the General Assembly is deeply concerned about your emotional well-being, but it hasn't yet gotten around to giving mental health days for school administrators. So we'll just have to wait for the next legislative session. With that, I'll turn the microphone over to Natalia. And Natalia has a second question to you, which of course is very interesting. Thanks, Natalia.
Thanks, Tom. And I just want to highlight one of the messages we received in the chat, which is that if all of our seniors during the spring semester need a mental health day at the beach, they're going to need to code it as a mental health day, especially if a parent calls it in as such. And the answer to that is yes. Unfortunately, you're probably going to see an uptick in mental health days. The good thing is that they're 2 non-consecutive days, and so you're not going to have them miss too much in 1 week. So I have the pleasure of addressing one of the what I think is one of the most interesting questions that came out of this legislative session, because I think we were all a little bit concerned when we realized that the state was considering legalizing marijuana for recreational use and sort of what that would mean in the employment context. So I will read you question number 2, but before I do, I have to say that my comedy street cred I owe all to Tom, so I can't even take credit for being funny. So the question I hope is very helpful in answering some of the concerns. So this is the question. One of the teachers in my building showed me his medical marijuana card and told me that he will be out in his car taking a Mary Jane break during his preparation period. Dude, for real? And the short answer to that is no, that can't happen. But let me tell you why, because I think there were a lot of really important questions raised early on in the legislative session by people who just didn't know exactly where this was going to go. So the public act that legalized marijuana for recreational use for people 21 and older is Public Act 21-1. But under that new law and an earlier law that some of you may be familiar with, which is the Palliative Use Marijuana Act, or as we commonly refer to it as the PUMA, boards of ed just simply don't have to permit the use of marijuana at school, even for those employees with medical marijuana cards. So that's the key. We do not have to permit it at school, right? And I want you to just keep that in mind, because I'm going to talk about a little bit, a few other points that might be of interest to you. So employers can prohibit the possession or the use of recreational marijuana in the workplace. And there's absolutely nothing in the law that requires an employer to allow an employee to perform his or her duties while under the influence of marijuana. I think we're all very comfortable with that piece, right? The piece that's interesting with respect to boards of education is that under this law, we are considered exempted employers. And what that means is that normally employers have to have a policy addressing these issues. But boards of education, because they're exempted employers, they don't need to have a written policy to take disciplinary action. And this is important because we are permitted to take disciplinary action against employees for possession, for use, and for the consumption of recreational marijuana outside of the workplace, right? So exempted employers can refuse to hire. They can take disciplinary action for possession, the use, or consumption of marijuana inside or outside of the workplace. And it's solely on the basis of a positive marijuana test, and we don't have to have a policy in place. So whether we do or don't, it's not really an issue relative to disciplinary action. The other thing that the Act addresses through its new language is it amends the definition of smoke or smoking to include marijuana. As you know, smoking on school grounds is prohibited, right? And so the Act clarifies that smoking is prohibited in any area of a school building or on the grounds of a school. Now, interestingly, any area is further defined, and that is considered to be the interior facility, the building or establishment, and the outside area within 25 feet of any doorway, operable window, or air intake vent of the facility, building, or establishment. So it's just kind of neat that they went ahead and further defined any area as it relates to a school. But what's interesting is that by contrast, under the PUMA, which is the Palliative Use of Marijuana Act, a qualifying patient is in fact protected, and employers can't refuse to hire. We can't penalize or discipline, including discharge, any employee on the basis of their status as a qualifying patient under PUMA. And they have to continue as employees to make reasonable accommodation for those employees that have to use marijuana outside of the workplace. So if you do have an employee that is a qualifying patient under PUMA, then we have to be careful about how we address some of the concerns that we may have relative to their use. Again, that doesn't mean that they can use marijuana in school, that they can be under the influence while discharging their duties, right? But we cannot refuse to hire them, penalize them, or discharge them based on their status as a qualifying patient, right? So that is the interesting piece, I think, about marijuana this legislative sessions, because the Act doesn't change the provisions of PUMA, right, relative to a qualifying patient, but it does sort of make some significant changes relative to what we can and cannot do and whether we need to have policies. So with that, I just want to conclude by saying that we have absolutely no requirement. There's absolutely no requirement in the law that would permit an employee to take a marijuana break during the workday or otherwise on any school grounds during the prep period. All right. So Tom, I'm going to turn it over to you for question number 3, which is a really interesting one and a timely one as well.
Before I get to question 3, I just wanted to note that there was 2 questions. Well, actually, one was answered. The handout will be available on the CAS website after the presentation, and the handout being available electronically has links to the various statutes as well as the legislative update. But the other question, and this goes back to question 1 on mental health days, are schools allowed to create an absence code called mental health, or do we have to do it cryptically? Well, that's a really good question, because normally when we think of psychiatric issues, we think of them as highly confidential. But in this case, it's not related to a medical need, but rather just an opportunity for a student to take care of his or her mental health wellness. And that would include going to the beach. So I don't see any need to, you can code it Mental Health Wellness Day. Any absence information is FERPA protected if it's personally identifiable. So there's no particular need to be careful. You just code this absence as you would code other absences by category. So now, question 3. We're perhaps remain rather desperate to find teachers to fill our classrooms this fall. And one of our new hires is just terrible. when can I cut her loose? And this is something that, as Natalia mentions, it's timely because under the tenure law, we all are familiar with the fact that teachers are non-tenured typically for 40 months of employment, unless they had tenure in another district in the preceding 5 years, another district in Connecticut, in which case they get tenure in 2 years. And otherwise, teachers are subject to non-renewal or termination during their probationary period. What you may know, and we want to make sure you all know, is that there's a super probationary provision in the tenure law. And that is that the definition of teacher, the employee who's covered by the tenure law, is a person who possesses certification from the State Department of Education, is in a position requiring that certification, and is employed for at least 90 calendar days. So I hope this is not a widespread problem, but we've already had a couple questions about terrible new hires and what can we do. And so during that first 90-day period, these people are not covered by the tenure law. So you do not have to convene a hearing to terminate and find one or more of the 6 reasons for termination. You certainly wouldn't want to wait for a non-renewal, because that means the terrible teacher works for the entire year and then doesn't come back the following year. And in that regard, it's always an important strategy question. Even if you've decided not to renew a teacher, when do you make that known? You have to make it known prior to May 1st. But if you make it known on October 12th, then we have a teacher who has no particular incentive to perform his or her duties effectively, because their employment is ending at the end of the year anyway. So you just want to be careful about that. But when we get to this super probationary teacher who is just not cutting it, we still have issues of due process under the Bill of Rights, the 5th and 14th Amendment. A governmental entity, and that would include you, cannot deprive a person of life, liberty, or property without due process. And if I'm employed as a teacher, I've probably signed a salary agreement, or at the very least, I've gotten a letter saying that I'm employed for the 21-22 school year. So I have an expectation of employment for the rest of that year. And I may even have a contract that I signed that you, in your wisdom, gave me to sign, and we have to worry about the terms of that contract. But any employment contract has an implicit term of satisfactory performance. You can't sign a contract and just not do your job and say, well, I have a contract. So there is always the right to terminate a contract for inadequate performance. So now the question is, what process is due in that circumstance? And although in the first 90 days, these individuals are not teachers under the tenure law, they're teachers under the collective bargaining law, and they're members of the teachers bargaining unit. So they have the right to union representation. Now, we know that the right to union representation is a right that people assert. You don't have to tell people that they have the right to union representation. Rather, you can wait for them to say, I don't like the way this is going. I'd like my union rep here. But we often involve the union even before a request is made, just as a question of fundamental fairness and also our relationship with the union. So in this particular situation, if you've decided to separate from your employment a brand new teacher within the first 90 calendar days, our recommendation is that you conduct a Loudermill hearing and involve the union. And a Loudermill hearing, some of you know that by name, and some of you know it as a pre-termination hearing that you would undertake even when someone does not otherwise have rights to employment. And that's an informal hearing where you tell the employee what your concerns are, and you listen carefully to the employee as to his or her response to those concerns. And based upon that information, that's a hearing and that's due process the person has notice of the charges and an opportunity to respond based upon the information you glean from that discussion through a Loudermill hearing. Then the district is in a position to either say, okay, well, we're going to support you and we'll try and make this work, or okay, we're not satisfied with your answer. We're not confident that you will be able to perform your work, and therefore your employment is terminated. So we just wanted at this early stage of the year, when we're all within the first 90 calendar days, to make you aware of that. The last question on this that we've identified is 90 calendar days from what? Someone might have signed their contract in July. Did the 90 days start running then? And as is often the case with Connecticut school law, our candid answer is we don't know. But we would take the position and believe it to be sound that the 90 days starts when a person starts working, because to the extent that there's a probationary aspect to this law, it makes no sense to have a probationary period running when someone's not performing his or her job duties. So we take the position that the 90 days starts with the first day of employment. That would typically be some orientation session. And keep an eye on the calendar, because once the 90 days runs, then a person is a teacher under the tenure law. And that person is subject to termination, but only through a hearing process. And that person is subject to non-renewal, but only at the end of the school year. So we hope you don't have to take advantage of this provision of the law, but we did want to make you aware of it. And I think we're doing pretty well on time. And so with that, and let me see, was there a question in the chat? No open questions. Very good. So Natalia, I'll turn it over to you for question 4.
Terrific. So question 4 is one that I think everybody has been very confused about, and rightfully so. So the question is, after we denied a parent's request to provide remote instruction again this year, she has now claimed that her child must attend school remotely this year because she, the parent, not the student, is immunocompromised. What should we do? So you all know that as a general rule, remote instruction is not required for this school year 21-22. I think that's sort of been beaten into every school employee's head from the beginning. Effective this past July 1st, the Public Act 21-2, it was originally 2146, and it was further revised through 21-2. It defines remote learning as an instruction by means of one or more internet-based software platforms as part of a remote learning model, right? The legislation doesn't require the provision of remote learning this year. In fact, remote learning is not authorized for this current school year. But the question has arisen over time as a result of different guidance that we've received from the State Department of Education and others around when we can, if at all, use remote learning. So, but according to the legislation that I just mentioned, for the school year beginning July 1st of 2022, the Act does allow boards of education to authorize remote learning for students in grades 9 through 12. But they can do so only if districts provide instruction in compliance with the standards promulgated by SDE for remote learning, and if they adopt a policy regarding the requirements for the student attendance during remote learning. So in other words, does it count, how does it count, so on and so forth. The attendance policy that school districts are going to need to create effective July 1st, 2022 has to comply with the attendance guidance and count, quote, as in attendance any student that spends at least half of the school day engaged in virtual classes, in virtual meetings, or in any of those activities that are logged through electronic systems, or completing and submitting assignments. The other thing we wanted to highlight is the Connecticut General Statutes 10-16, and don't worry about writing this down because you will get all of this information in your materials. It provides that each school district has to provide at least 180 days of actual school sessions for those students that are in kindergarten through grade 12. Now, you all know that, right? Section 17 of the Act as amended by one of the sections that we talked about in the special session Public Act 21-2, sorry, amends that statute effective July 1st to provide that remote learning can be considered, shall be considered actually, an actual school session. Because that was one of the questions that we had as this legislation was developing. Should we consider this an actual school session? Will it be considered? And so the answer is it will be, right? But it has to be provided that the remote learning complies with those standards that I just mentioned, developed by the Commissioner of Education. Now, those standards have not come out. They are due to come out January 1st, 2022. And so we're not currently authorized to consider remote learning a school session, but there's more to my answer, right? As some of you may already know, because you may have been present when this presentation was put together, there was a PowerPoint presentation in early August, I believe it was August 9th, where the Commissioner of Education informed superintendents that they were encouraged to develop administrative procedures or regulations regarding continued educational opportunities for 3 types of students. Those students that are in isolation or in quarantine, those whenever there's a localized outbreak, and the last one, which is the most confusing, I think, for everyone, is students with vulnerable family members. That was the first time that we became aware that the State Department of Ed was actually encouraging remote instruction or continued education for continued educational opportunities for students with vulnerable family members. As you may recall, throughout the entire pandemic, we never made accommodations for students with vulnerable family members. But through that PowerPoint presentation, it became clear that superintendents had to sort of scramble and figure out what they were going to do. A few days after that, there was a further email that was sent. I don't know whether everybody has seen it, but it was an email sent from the Office of the Commissioner in which they elaborated further on what they meant by continued educational opportunities for those students with vulnerable family members. And they told superintendents that school districts were encouraged to develop policies so that they could provide continued educational opportunities for those three categories of students, right? And they told them the decisions regarding the program for these students and circumstances had to be made on a case-by-case basis, right? We couldn't just develop one black or white bright line rule. And that they were encouraged further to consider a variety of continued educational opportunities. And so we sort of all scratched our heads and we had no idea what that meant, and then quickly realized that remote instruction for those individuals could potentially be an accommodation, because further in that email, they were reminded, the superintendents were reminded by the commissioner, that the 2021 remote learning legislation doesn't supersede the IDEA or Section 504, which meant that any decisions regarding the programming of educational programming for students with disabilities had to be made through the PBT process or through the 504 teams, however appropriate. And so if for that particular student, it was necessary that we provide remote instruction, then through the PBT process of 504 team, we would be able to figure that out. So what's critical about this guidance is that when a family requests that a student receive remote instruction because they have a vulnerable family member in the home, school officials are actually required to consider that request on an individual basis, even though we have this new legislation that says remote instruction is not permitted, right? But in doing so, school officials have to keep in mind a couple of things, and I just want to sort of touch upon a few of them so that, and again, this will be in the material, so don't scramble to write this down. But the main thing is that every request has to be considered individually, right? That is critical, just like we would with any sort of ADA accommodation or any other request that we would get. Every request is to be considered individually. In-person instruction, if feasible at all, is the absolutely best solution for the students. So we need to try hard to encourage in-person instruction if it is feasible, right? Another thing that districts should consider is they should consider the requests is an exemption from in-person learning. So the request should look similarly to those requests that we've received early in the pandemic and probably continue to receive for mask exemptions. So it's an exemption from in-person learning, right? And they should be supported by medical evidence, and school officials and the parents should sort of meet and talk together about alternatives, such as risk mitigating steps that we can take that would permit the student to continue to receive in-person instruction. So think of this as an exemption from the general rule, which is in-person instruction is best for the student. And the last thing I want to just mention is that if school districts do decide to grant the exemption and provide remote instruction, school officials are free to consider different options. And one of the options that was embedded in that email is sort of internet-based instruction, right? We're not obligated to provide dual teaching where students will participate remotely in classes as they would otherwise. If, throughout the pandemic, we had that dual teaching for a while, but you're absolutely not required to do that. So it's important that if you get these requests, you work closely with your legal counsel, because we need to establish sort of safeguards around this and appropriate procedures for considering how we should act on these requests, because they are quite complicated. So with that very lengthy response, I'll turn it over to Tom for question 5.
Great, thank you. And before we talk about our cheerleader student, there was a question in the chat. Is a student with a compromised family member a student with a disability? And we believe that is not the case. And interestingly, one of our clients has already been the recipient of an OCR complaint claiming that by not accommodating the family member, there's some violation of the law. But the duty to accommodate is typically a duty owed to employees under the ADA or under this or to students under IDEA or Section 504. So we don't see this as governed by those statutory provisions, but rather it's an accommodation identified by the State Department of Education, and we're through the Commissioner of Education. So we want to do what we can, but we don't consider the student disabled if he or she is not disabled and the issue relates to a compromised family member. So question 5, I heard that the vulgar cheerleader won her case at the Supreme Court last June. How bad is the decision for us school people? Well, I would like to defend Brandy Levy's honor. She's not a vulgar person. She had a bad day, and her bad day was when, after being a JV cheerleader for a year and going out for the varsity squad, she didn't make it, and she was quite disappointed. And she and her friend went on Instagram and posted some vulgar, some pictures with a vulgar caption, F cheerleading, F softball, F everything. So that's on Instagram, middle fingers raised, caption in place. And one of the other cheerleaders ratted her out to the coach, and they brought her in. She apologized. They said, that's not good enough. You're off the team for the year. And as I often mention in talking to school administrators or aspiring school administrators, decisions you make in the normal course of business can land you in front of the United States Supreme Court. And that's what happened here. Her parents sued and claimed that she was simply exercising her free speech rights. And in June, the court decided the matter. So we have a frustrated cheerleader off campus. Interestingly, cheerleading is a voluntary exercise. It's not a basic educational right, but nonetheless, students have constitutional rights no matter what they're doing. So we had this cheerleader off campus posting vulgarities on Instagram, and then asserting she has a free speech right to do so. This was the fifth in a series of cases involving the free speech rights of students. And the first case was decided in 1969, and it's one that I'm sure all of you are familiar with, Tinker versus Des Moines Independent Community School District. Mary Beth Tinker, her brother and her friend wore black armbands, even though school administrators were tipped off and they passed a rule prohibiting black armbands. So they got suspended, and Mary Beth Tinker said, you violated my free speech rights. What was that case created a fundamental shift in school law, because as you've probably heard, in loco parentis is the doctrine that says that teachers and administrators are like parents and have parental authority over students when they come to school. So that was the law until Justice Fortas in Tinker said, it can hardly be argued that students or teachers shed their constitutional rights at the schoolhouse gate. So suddenly we now are viewed as the government. And when students exercise their rights of free speech, we have to look at any restraint in that exercise as one imposed by the government. The court in Tinker recognized that school officials have special interests in regulating student conduct in order to maintain an effective educational system. So they said, yes, Mary Beth Tinker has free speech rights, but school administrators can regulate speech when they reasonably forecast material disruption or substantial interference with the educational process or the invasion of the rights of others. So that's the framework. And over the last 52 years, we've worked within that framework. And the case that we're talking about is Mahoney Area School District versus BL, Brandy Levy. That case tested whether Tinker applies to off-campus conduct. Before we get to the Mahoney Area School District case, I just want to touch on the evolution of student free speech rights. We have in 1986, Matthew Frazier suing because he was suspended for being vulgar in a student assembly. And the court ruled that school officials can regulate vulgarity in school without a showing of disruption. Then we have Hazelwood School District versus Kuhlmeyer about the school newspaper. And the court ruled that school officials can regulate the school newspaper without a showing of disruption, as long as they have a legitimate pedagogical interest. Then nothing happened until 2007. So we go from 1988 to 2007 and now to 2021. But in 2007, the court addressed what is affectionately known as the Bong Hits for Jesus case, where a student unfurled a banner saying Bong Hits for Jesus. And he was suspended, and the court had to decide whether that suspension was in violation of his free speech rights. And on a 5-4 decision, the court reversed the Ninth Circuit and held that suspending him was not a violation of his free speech rights, because speech that can be understood to encourage drug use can be regulated without a showing of disruption. So throughout that, Tinker remained the law of the land, and these were exceptions to Tinker. What happened in the BL case is that it was appealed, and she won in the district court, and it got to the Third Circuit, the Court of Appeals for Pennsylvania, which is right below the Supreme Court. And the Third Circuit gave all of us a heart attack, or school board lawyers a heart attack, because it ruled that school officials have no authority to regulate speech off campus. And the Tinker rule does not apply. So it's just a civil matter. If you think off-campus speech is a problem, call the police. And so it was deeply concerning because of our responsibilities, for example, to deal with bullying in the school setting. So here we have the Third Circuit saying Tinker doesn't apply and you can't do anything to Brandy Levy. So that was the posture of the case that came to the United States Supreme Court. Well, when it got to the Supreme Court, we had an 8-1 decision upholding the validity of Tinker and upholding the rights of school officials to regulate off-campus speech. They did the Brandy Warner case even at the Supreme Court, and appropriately so, because even under Tinker, you can only regulate speech if it materially disrupts or substantially interferes with the educational process. And it's really hard to show how some impulsive post on Instagram was materially disruptive or substantially interfering. And so it's interesting, hindsight's a wonderful thing. I wonder what I would have said when they come to me and say, we got to do something about this Brandy. Do we have the right to suspend her? But fortunately, I wasn't asked. And now we have guidance that particular scenario of some kid posting vulgarities while off campus on social media, in the absence of a showing of serious disruption, is an exercise of their free speech rights. As the court struggled with this, the court did recognize that student free speech rights are more robust off campus, that whatever jurisdictions teachers and administrators have over students on campus, deriving from the in loco parentis doctrine, relates to the legitimate interests of the school. And the school is not the parent when a student is not in school, and it has no legitimate interest in regulating vulgarity outside of school. So she won her case, but the takeaway is that in many ways, school districts won as well. And that is that the court recognized that there are circumstances where off-campus conduct does directly implicate the interest of school officials. And I'd like to just read you from Justice Breyer's opinion. And this is in the materials, but he wrote, significantly, however, this is after he's talking about the Third Circuit decision, and in light of the realities that most modern day discourse takes place through internet communications, the court also recognized that some off-campus speech is harmful and should be regulated. The school's regulatory interest remains significant in some off-campus circumstances. These include serious or severe bullying or harassment targeting particular individuals, threats aimed at teachers or other students, the failure to follow rules concerning lessons, the writing of papers, the use of computers, or participation in other online school activities, and breaches of school security devices, including material maintained within school computers. So the court gave us this list of legitimate concerns, which significantly includes what they describe as serious or severe bullying or harassment. So we just wanted to, some of you have heard about this case, and we wanted to share with you the fact that although on paper, the school district lost, and we think appropriately so, given the lack of disruption, the standard established by the Supreme Court is helpful, and we maintain jurisdiction over off-campus speech when it falls within those serious categories of behavior that implicate school interests. So I see no questions, so I'll turn it over to Natalia for question 6.
Thank you, Tom. My secretary got up in the middle of the afternoon the other day and told me that she was going to a union meeting for the rest of the day. Can she do that? The short answer is no. She absolutely cannot just do that. But before we just rely on that basic no, I do want to let you know that there have been some significant changes with respect to obligations by public employees, which includes obviously a Board of Education, regarding union access and payroll deductions. And that is Public Act 2125. And some of you may already be familiar with this, particularly if you've been at the bargaining table with some of your contracts this fall. The union has raised this type of obligation, at least to me, on more than one occasion. And so let's just summarize a few of the key aspects of this new legislation. So the new law is most definitely in response to Janice, right? And in fact, I think I was a little surprised that it took them so long, since 2018 to now, to come up with a way to make unions feel more valuable and to sort of earn their keep, so to speak. So, but in Janice, as you know, the court reversed a precedent that the court had for 41 years, which held that mandatory agency fees for public sector employees were permitted. But the court in Janice actually reversed that and said that if you do require mandatory agency fees for those public sector employees who don't join the union, you are violating their First Amendment rights. So the precedent was that you once could charge mandatory agency fees and now you cannot. But the new act that I'm talking about, 2125, imposes a few new requirements on us as boards of education. But and like I mentioned, if you've been at the bargaining table time and time again, you've probably read some of the proposals from unions that have frequently asked to be permitted access to employees during orientation, to be given their email, to be given their information once a quarter, so on and so forth. So this act truly sort of solidifies some of the main issues that unions have been talking about at the table since Janice. So the most germane to the question that I just posed, which is, can she just get up and leave? We just wanted to note that unions have a statutory right now to meet with employees in the workplace. However, they don't have the right to meet with employees during work time, right? So that is key as it relates to this question. They can meet with employees in the workplace, but they can't take away from their work time. The new requirements under the law for union access are that they can meet with individual employees on the employer's premises during the workday to investigate or to discuss grievances or any work-related complaints or any other issues that arise in the workplace, right? They can conduct worksite meetings on the employer's premises before and after the workday. They can also do that during their meal periods or other paid or unpaid breaks, right? And the last one is that they can meet with a newly hired employee within the bargaining unit without charge to the employee's pay or leave for somewhere between 30 and 120 minutes within the first 30 calendar days of being hired. So during orientations, they can do that, or if the employer doesn't hold any orientations, they can hold individual or group meetings to talk to them about union business and welcome them into the bargaining unit. Other requirements that we thought might be important for you to know, and again, this will be in your packet and there will be links in the packet because you'll receive it electronically to the actual act if you're bored late at night and feel like you need to read this. But public employers now are required to provide the exclusive collective bargaining representative, right? So the union, with a newly hired employee's name, their job title, the department and work location, their work phone number, and their home address. And it has to be provided, and this is something that I found interesting, it has to be provided in an editable digital format. And if at all possible, in a format that is agreed to by the union, right? The employer also has to provide the information with real-time electronic transmission of new hire data, right? So as soon as it comes in, you have to send it over. But if you're unable to do so, you have up to 10 days after the employee was hired or the first pay period of the month after the employee was hired, whichever date is earlier. And so that is right now, as of right now. The other thing, well, I shouldn't say right now because we're still not in October 1st. But the other requirements that will be coming up on January 1st of 2022 is that we will be required to provide the union with the name, job title, worksite location, work phone number, the hire date, the work email address, and the home address effective January 1st, 2022. And we have to provide this information again in one of those editable digital file formats that the union agrees to every 120 days, unless the parties agree to something else. And some of you may have seen that in some of your contracts, it says, you know, the union shall receive a copy of the list of the entire bargaining unit, their name, job title, so on and so forth, in September and then in January. So unless the agreement specifies more frequent or detailed lists than every 120 days, even if your agreement says you only provide it twice a year, you have to do it every 120 days, right? So in addition, one thing not to forget, and this almost slipped my mind, is that if there's any other employee information that the union is entitled to, you also have to turn it over, right? If authorized by the employee via one of those written authorizations provided to the union, the information that I just mentioned can also include the employee's telephone number, their personal cell phone, and their personal email address if you have it on file. So if they specifically want you to provide that information to the union, they have to tell you. Another thing that is important in this new public act is that the union has to be given access to employee orientations. I know that I certainly fought this long and hard in many negotiations where I didn't feel like this type of language was required in the contract because it was union business. But unfortunately, this new legislative session sort of decided that I was wrong, and that now we are absolutely required to give them access to new employee orientations. Thankfully for most unions, I was voted down at the negotiating table and reminded that most unions do have access to employees anyhow, but you have to be given access to employee orientations as a union, and they must be given notice of the orientation at least 10 days in advance so that they can prepare, right? If there is any concerns about any of the issues that I just raised, any of the things that are new in this act, the parties can negotiate about those issues upon either party's request, right? And in the event that the parties are unable to reach some sort of agreement on these issues, the new statute provides for this expedited arbitration process regarding those issues. And there were two just final things that I want to mention because I know we're pressed for time and we still have 3 more questions. The act permits public employees and also retirees to authorize deductions from their salaries, wages, or retirement benefits to pay for union dues. And it regulates how employers can require employee authorization of deduction for union dues. That's another issue that we bargained about shortly after Janice deciding sort of we need written authorization. How do we know that the person wants to be in the union? How do we know that they don't want to withdraw? Well, now public employers have to rely on the certification from the union attesting that the employee that you're talking about has provided a written authorization for those deductions. And we as an employer, because of this act, can't require that union to produce the authorization. We cannot require them to do that, right? Unless there's a dispute over whether or not the employee provided that authorization, right? It also provides that the employees may now withdraw their authorization only in accordance with the terms of the authorization. Some of you may have seen that those authorizations have a drop dead date by which they can withdraw, and other dates, and after that, they're sort of out of luck and they're stuck in for the whole year. So now the act makes it clear that employees can only withdraw for the deduction of union dues only in accordance with the terms of that authorization. And the organization must indemnify, meaning the union has to indemnify employers if it makes an improper deduction. So, and the last thing I'll just mention is that it will be a prohibited labor practice under this act for any board or any public employer to do any of the following 4 things. We can't encourage an employee to resign or decline membership in a union. And all of these things, by the way, we know because I think we've all beaten it into your heads that we can't interfere in union business, but we certainly cannot encourage an employee to resign or to decline membership. We can't encourage an employee to revoke their authorization for payroll deduction dues. We can't knowingly aid an effort by any other entity to do these things. And we also cannot allow an entity to use the employer's email system to discourage membership in a union or to discourage authorization of payroll deductions for the union dues. So with that being said, I will turn it over to Tom for question 7, although let me see, I think there might be a question in the chat. Union business. If language in current bargaining agreement states release time for union business, does that still apply? I'm guessing the answer to that, I mean, the question refers to if somebody can go to 2 or 3 conferences during a year, can they still go? If that is what the question is asking, that the answer to that is yes. But Tom, I see that you have your microphone on and you may want to respond to that further.
Well, I just wanted to confirm that this legislation is supplementary. So whatever rights unions negotiated in the past still apply, and the new legislation may impose additional responsibilities on the employer. But let's turn to question 7. That is, my superintendent is now insisting that I ask only pre-scripted questions in job interviews. Why would I have to do that? And this is an opportunity to remind us all of the way in which discrimination issues are addressed through the courts, and also to inform you of 2 new protections against discrimination. But we have to start with just the question, when a person claims that he or she was the victim of discrimination, how does the CHRO, the EEOC, the courts, how do they decide whether that's a valid claim? And I would go back to something I saw early in my career, back in 1977. Excuse me, the Connecticut Supreme Court, in discussing discrimination complaints, said, quote, "One who indulges in discrimination does not usually shout it from the housetops. All too frequently, persons publicly announce abhorrence of racial prejudice while privately practicing it." So that's the framework. In other words, the courts recognize that discrimination is not something people admit, but rather we have to determine whether discrimination occurred by inference. And we look at all the facts and circumstances. And if any of you have answered a CHRO complaint, you know, in Schedule A, they always ask, well, what did you do in all these other circumstances? And then if one can draw an inference of differential treatment, then that may support the claim of discrimination. So when we come to job interviews, when we ask everyone the same questions, then we avoid a claim that because of my protected characteristic, let's just take me, I'm old, so I'm in a job interview and they ask me all the tough questions and they ask the other people the easy questions. And I claim that they were just doing that because they didn't want to hire me. So asking the same questions of everyone is a help to avoid that kind of claim. But because we deal in a world of inference, I don't want to suggest that you're hamstrung in an interview process. And we have to strike a balance between protection against claims of discrimination and having an effective interview process. So our recommendation would be have the same questions posed to all people you're interviewing, but then follow up based on what they say. And that's perforce going to be different from candidate to candidate. But to just sit there and ask the question, and no matter what the person says, not ask any further questions, we think would go too far the other way. And in this regard, we did want to bring to your attention two changes in the law. One is that you can't ask in an initial application for information that would reveal a person's age. So you can't say, oh, what year did you graduate? Or other information that would reveal one's age. So we have to be now careful about that. And in addition, early in the session, the General Assembly passed what it was described as the Crown Act. And this new law, as you well know, discrimination on the basis of race is strictly prohibited. And race now, under Connecticut law, is defined as including ethnic traits historically associated with race, including but not limited to hair texture and protective hairstyles. And protective hairstyles is defined as including but not limited to wigs, head wraps, and hairstyles such as individual braids, cornrows, locks, twists, bantu knots, afros and afro puffs. So this is now considered to be part of race, and you certainly want to not pay any attention to that personal exercise of choice in appearance that is now protected under Connecticut law. And finally, I'd just like to say that it's important that not only you, but everyone involved in the hiring process be trained as to discrimination claims and protections. Because if, for example, you have an interview committee and you invite some parents or teachers and they don't know what they're doing and they start asking questions that could give rise to adverse inferences, then you've just created a problem for yourself. So these concerns about how discrimination complaints work and the protections against discrimination, they should be shared with everyone who's involved in an interview process. And so now we have two questions in the chat, and then I'll turn it over to Natalia. But the first question is, can college transcripts be required or high school diploma for initial applicants if either could indicate age? And the answer is you can require the transcripts, but I think you have to tell people that they can mask the graduation date, because you can't ask in the first instance for that information. I suppose, though, you want to know whether someone has a diploma or a college degree, and that would be legitimate. And so the next question is, can you please review that one more time? Because I read it quickly. Head wraps, rags, etc. Can we still ban colors, patterns? And I'm not going to answer that question in general. I think, and in the handout, you'll receive the specifics of the statutory protection. But I think you're going to have to look at those questions on an individual basis. Why would you ban colors? Where do the colors appear, et cetera? So that's a great question, but I think you're going to have to look at the individual circumstances. And someone is circling us back to mental health wellness days. What if the parent refuses to write a note for the student and the student self-reports it? So I see Bill is going to jump on that question, and I would just say that that would probably be something you'd want to talk more with the parent about. I know some parents just like to say no to cause trouble, but under the excused absences, I still think that well, let me just look at the statute. It says, shall permit any student to take 2 mental health wellness days. So let's hope we don't have to answer that question in general, but I would say I wouldn't pick that fight. If everyone knows it's a mental health day and this parent is just saying, well, I'm not going to do your work for you, I'm not going to sign that form. I would, I think we have to pick our battles, and that wouldn't be a battle I would pick. So Natalia, question 8.
Terrific. This is a fun question, but it's a very serious question. And it's one that I think a lot of school employees are struggling with, because the pandemic has certainly taken way too long. I think we're all just exhausted, and we had hoped that through the vaccine, we would be able to be at a different place. But let's see if I can give you a little bit of clarity around this, though you're probably not going to like my answer. Just tell me one thing. If I have to get vaccinated, when can I expect that the students who breathe on me will have to do so as well? So I think you all know that there isn't a requirement that students be vaccinated against COVID. And so under current law, we as school officials can't condition a student's school attendance on a vaccination requirement, right? As we've seen with vaccination requirements for school employees and contracted workers, those mandates are very complicated because we have medical and religious objections. And to the extent that some individuals were hired prior to September 27th, they also have the ability to just frankly opt out of the whole vaccination process. And so the prospect that a vaccination requirement is going to be implemented for students seems highly unlikely at this point, particularly given the fight that the General Assembly just picked with parents who are completely against vaccination. And so let me touch upon that just very quickly so that you're familiar with the changes in the law as it relates to immunizations. So this year and going forward, the General Assembly has eliminated the religious exemption from the established vaccination requirements for students. And the act became effective on April 28th, 2028, and it modified the law in several ways. The law originally permitted exemptions based on religious beliefs for students that were enrolled in kindergarten through grade 12. But now that act completely eliminated that religious exemption for certain students, right? But there's this sort of grandfathering legacy provision embedded in the act. And what they were able to do for those parents that were just completely against the General Assembly doing away with this objection, any kid who was enrolled in kindergarten through the 12th grade on or before April 28th of this year, 2021, and whose parent or guardian had obtained and presented a religious exemption to the school before April 28th, they could rely on that exemption. So let me just say that again. So if you were enrolled in a school on or before April 28th, and the parent obtained a religious exemption before the 28th, they could rely on that exemption. And that included students who transfer from another district or from a private school with an exemption in place, right? So with respect to the required timing of vaccination compliance for kids enrolled in preschool through or pre-kindergarten, the act contemplated two primary categories of students. The first one is any child who was enrolled in a preschool or other pre-kindergarten program and who had presented a religious exemption before the 28th and who presents a declaration from a physician or a physician's assistant or, advanced practice nurse and so on and so forth, stating that initial immunizations have been given to the child and that additional immunizations are in process according to some alternative vaccination schedule, and in compliance with a form issued by the Commissioner of Public Health, had to be fully vaccinated according to the alternative vaccination schedule. The other bucket of students that they considered was any child who is enrolled in a preschool or another pre-kindergarten program who had presented a religious exemption before April 28th and who did not present a declaration from a physician or physician's assistant and so on and so forth, had to comply with the state's immunization requirements by the later of September 1st of 2022 or 14 days after transferring to the district. So if you didn't have, if you were enrolled and you didn't have a religious exemption before the 28th, right, you had to comply with the immunization requirements no later than September 1st of next year or 14 days after transferring into that district. The other thing that the Act does, it continues to, just to clarify, the Act continues to exempt a child who presents a certificate from a doctor saying that it's contraindicated because of a health condition, right? That is still there. It's just a religious exemption that went away. When it becomes available, which is going to be available on or before October 1st, a certificate presented from the physician or the physician's assistant has to comply with this form prescribed by the Commissioner of Public Health. Again, we still haven't seen it. And, it's September 22nd today. So it's possible that between this week and the next, we'll get it. But after October 21st, it has to certainly comply with the requirements of that form that the Commissioner of Public Health is prescribing, right? And that form will hopefully be available on the Department of Public Health website. That is what they're required to do, and that is what we hope they will do. The other thing that I want to mention is that if a parent or a guardian of any child that is unable to pay for the required immunizations, if they're just unable to pay, the expense of those immunizations shall, according to the law, upon recommendation by the Board of Education, be paid by the town. So there's sort of a subsidy provision because the interest, everybody recognizes that it's in the interest of public health for students to remain immunized and to continue to get immunized. And the last thing I'll just mention is that We still have the requirement that boards collect and report immunization to the Department of Public Health. But in addition to the old requirement, we are now required, well, we are not, the Department of Public Health is required to release annual immunization rates for each public and non-public school in the state. You may recall that there was a big to-do about this last year, and the parents were demonstrating all over the state because DPH was going to release the information. But don't fear, for those of you that have concerns about confidentiality, any data that's released by DPH will not contain information that identifies the specific individuals, just simply how many kids are vaccinated in that district and how many are not. And in the packet that you'll receive, you'll see that there's been additional guidance issued by the State Department of Ed with respect to this public act that went into effect April 28th. And we've hyperlinked it so that you can read it at your leisure if you're interested. So I will turn it over to Tom for question 9.
And before I get to question 9, there was a comment and a question. The comment was that banning colors has to do with gang activities, and there are cases on that, but that typically involves students and colors, and at what point can you ban gang colors, and that has been looked at under the Tinker case, but our discussion here was more about the employee, and I'm not aware of any employee being prohibited from wearing colors because of gang affiliation. But again, my suggestion is let's look at that case individually and look at all the facts and circumstances. The other question in the chat was why, and this might just more be a rhetorical question, why, if a person has a medical exemption, are they treated the same as everyone else who's refusing the vaccine? Seems a bit discriminatory. Am I wrong? And well, there are differences in the two situations, but the underlying health concern is the same. We have a person who's not vaccinated. And so what do we do about that? And whether the person's not vaccinated because of a medical exemption, a religious exemption, or they've simply refused the vaccine, the question is, how do we reduce the likelihood of COVID spread? And that's by testing those people. And so finally, if a school is planning a field trip to a location that requires vaccinations, is this an instance where we would need to say students need to be vaccinated to attend? And the answer is yes. If essentially, I mean, there are circumstances where kids need a passport or even a visa for a field trip. And if that receiving country says that people entering the country need to be vaccinated, then that's not your business. It's the country in question, but you would have to defer to that rule. So now question 9. One of the secretaries at my school worked remotely all last year. Can we make her come to work in person this year? And as with so many questions, including the one I was just talking about with colors and hairstyles, it depends, and we have to look at the individual circumstances. But this question is an opportunity to just remind us all of the way we approach these questions. The first question is, well, why did they work remotely all last year? We might say because we let them, or they wanted to. And if that's the case, then there's no further discussion. We would say it's time to come back to work. But some people worked remotely last year because of health concerns. And now we're in a new school year, and what are their rights relative to those health concerns? When we were in the pandemic, well, in the throes of the pandemic early on, we all were remote as a way to address the pandemic. But now we're not, and we have students back in school. So the question is in-person work an essential job function? If it is, it doesn't matter that a person has a disability, because if in-person work is an essential job function, then the person who can't work in person is not otherwise qualified, and it's not discriminatory to say that that person can't work. the pandemic caused us to re-examine the premise, when is in-person work required? We might say that there are certain support functions that have to be done in person. In fact, perhaps many support functions should be done in person, and the same is true of teaching. But we have to look at this from an individual case basis, because under the ADA, we always have to consider the individual. Is that person a person with a disability? How does that disability affect his or her ability to do his or her job? Is it possible for that person to fulfill the essential job functions with or without accommodation? And so we need to be very careful about not over defining in-person work, but if we have a legitimate position, we would explain that to permit that person to work in person, notwithstanding his or her disability. And if ultimately that's not successful, then that person is not qualified to continue in employment. I will turn it over now to Natalia for question 10, and we may have a couple minutes for additional questions, but we'll first make sure we answer question 10.
Thanks, Tom. So the last question we wanted to put on here is more of a reminder than anything, because a lot of different school districts have asked about this. So the question is, it took me hours to read through the entire legislative update, and I sympathize because it took me hours as well. However, I didn't see anything about bullying. I thought there was a change. What gives? The answer is yes. In fact, there was a change, and that change became effective July 1st of this year. You may recall that the bullying definition used to be a repeated use by one or more students of a written, oral, or electronic communication, or a physical act or gesture by one or more students repeatedly directed at another student attending school in the same school district that caused physical or emotional harm to the person or to the places, or the student was in reasonable fear or created a hostile work environment, so on and so forth. And so the new definition more so aligns with the definition of harassment that you're probably all very familiar with. And so effective July 1st of this year, bullying is defined as an act that is direct or indirect and severe, persistent or pervasive, which causes physical or emotional harm to an individual, places an individual in reasonable fear of physical or emotional harm, or infringes on the rights or opportunities of an individual at school. And the definition, again, will be in your packet, but it is very different than the original definition, right? Although the second sentence embedded in the definition is the same, right? Which is bullying shall include but not be limited to a written, oral, or electronic communication, so on and so forth. The question that this new legislation, or old legislation, but newly implemented legislation presents, is how the new first sentence changes the landscape of bullying. And so we wanted to raise a few points for you to consider, because there's reference to students as those potentially engage in bullying conduct, and reference to the potential victim as, quote, another student at school in the same school district. Those were in the old definition, right? So having a student doing the bullying and the victim being the person being bullied, particularly a student attending the school in the same school district, that is no longer referenced in the new legislation. And there's no limiting description of who the potential actor could be. And the potential victim is described simply as, quote, an individual. And so even though we read the definition in light of the required elements of the safe school climate plans, we just don't know whether there could be a potential bullying claim by or about a school employee, right? We just don't know, because there's no longer reference to students as those potentially engaged in bullying conduct or those being bullied. There's also reference to repeated acts in the old definition. In the new definition, there is not. Actions by any potential perpetrator now have to be severe, persistent, or pervasive, and it has to cause a physical or emotional harm to an individual, places an individual in reasonable fear of that harm, or infringes on the rights and opportunities of that individual. So that reference of repetition, which we were so familiar with in the last bullying definition, has also been deleted. With respect to cyberbullying, I think we need to read this new definition sort of in concert with the decision that Tom mentioned, which is the Mahanoy Area School District case, that famous cheerleader case. But I think given sort of the robust free speech rights students have off campus, as acknowledged by the court in that case, we have to keep in mind the court's description of the limited circumstances when school officials can actually take disciplinary action against the students, right? And those circumstances, as you may recall, and you'll see in the materials, are serious or severe bullying or harassment targeting particular individuals. So when you're investigating and taking action on these bullying complaints, you should take to heart the requirement of the amended statute that to constitute bullying, these actions have to be severe, persistent, or pervasive, as they would be in harassment. And the last thing that we just want to note, just for your reference, is that Section 1 of the Public Act that made this change to the bullying definition established, quote, a social emotional learning and school climate advisory collaborative. One of the duties specified for the collaborative is to develop a plain language explanation of the rights and the remedies available under certain sections of the law, and to distribute those rights and remedies to the parents, and to provide that explanation to boards so that boards could put them up on their website no later than January 1st of 2021. Well, that hasn't happened. We have not seen it, but it's pretty clear, at least to us, that we have to comply with that law. But the collaborative hasn't published that plain language explanation, and we think that we read the current law, which is Connecticut General Statute 10-48, to define the educational interests of the state as including that mandates in the general statutes pertaining to education be implemented. And so through Section 10-4B, as some of you may be familiar with some of the hearings that have been requested under that section, 10-4B sets a procedure by which anybody, whether it be residents of a community, parents, or students who attend school in that community, can file a complaint against the State Board of Education alleging that a Board of Ed has not implemented the educational interests of the state. And so presumably parents who believe that a school district hasn't followed the requirements of the statutes, specifically as it relates to these bullying complaints, will now be notified of their right to file a complaint with the State Board of Education. That's what we think that the plain language explanation will say, right? That you have the right to file a complaint with the State Board of Education alleging that we as a board haven't implemented the educational interests of the state. So I have 1 minute left, and I don't know whether there are.
And let me just jump in with that last minute. We just have a couple questions here. And does the new statute require any objective standard relative to victims' feelings or response? The statute refers to acts that cause physical or emotional harm to the individual. And the act has to be severe, pervasive, or persistent. So there is a reasonableness standard, but if someone says I was harmed, you have to think about it and have to make that decision. And then the last question is, what are the implications for reporting bullying that takes place among students from different school districts? And that's a great question, and we wish you all the best in figuring that out under the new law. All we know is that it's no longer possible to say, oh, that kid is from a different school district. I don't have to worry about it. And with that, we'll turn it over to Bill. And I just want to thank all of you for your attention, your good questions, and we hope that this was a helpful time.
Tom and Natalia, thank you so much. Terrific presentation. You made my job easy answering all the questions as you went through in a very timely and specific way, and a lot of terrific information. So I want to thank you for being here today, both of you. As I said before, such great friends to CAS, and we always look forward to your presentations, and you always give us much to think about. I want to thank again CAS's corporate partners, the college funding coach, Horace Mann, and MCM Fundraising for their support of professional development for Connecticut's school leaders. I want to thank everyone in the audience for attending. We will have a recording of today's webinar available. That will be available in a few days. You'll receive notification when it is available, and the PowerPoint and the other information that Tom and Natalia have to share with you will be made available as well. So you'll have some assigned reading coming to you, but again, informative and I know very helpful. I hope you will attend future CAS programs coming up this school year. I want to let you know in particular on October 14th, we're proud to host our second Education Equity Summit titled Inclusive Excellence. Among the speakers will be widely known Principal Baruti Kafeli, author of the Equity and Social Justice Education 50, Ingrid Kennedy, the Executive Director at CIRC, and we'll also have a panel of Connecticut principals. The summit is from 8:30 a.m. to 12:30 p.m. on October 14th, and registration is now open. Please see the weekly news blast for information. Also visit our webpage at CAS-CIAC.org for information on all CAS events and activities. Also in our news blast, don't forget to check out the legal mailbag, which Tom and Natalia and their colleagues provide for us every week. So on behalf of all of us at CAS, thank you again to our presenters. Thank you again to the folks listening in. I wish you well. Have a great day and a great rest of your week. Thank you. Bye, everybody.